Boy, I'm sorry for say this, but Usain Bolt and everybody else will invest in a SSL get what they don't get. Guys, I come with an update about the fraud hit Stocks and Securities Limited. You don't go nowhere. So the government is moving to wind up scandal hit SSL. However, the Financial Services Commission declares that the financial entity doesn't have enough funds to pay off its debts. The government is moving to shut down scandal-scarred investment firm Stocks and Securities Limited, as the Financial Service Commission, is arguing that the company does not have enough money to pay off its debts. Then something could have really go so. Look how much money them a thief up and never put it to good use. The wind-up under the Companies Act is reportedly being sought because the FHC believes SSL is insolvent on the basis of the findings from temporary manager for SSL Kenneth Tomlinson, who the regulator installed on January 17, 7 days after receiving reports of a multi-billion-dollar fraud. Up to January 31st, SSL had assets of 1.1 billion and liabilities of 1.2 billion. Losses for the year so far amounted to 184 million, in addition to negative equity of around 29 million. Loans totaled 623 million. Listen, them big figures here, I hurt my head. Reports are also emerging that 29.2 billion in assets found on the company's off-balance sheet covers the original investment of the 8,000 active clients of the beleaguered 50-year-old private firm. A shortfall of close to 200 million exists when liabilities of around 29.4 billion are subtracted. A balance sheet is a financial statement that reports a company's assets, liabilities, and shareholder equity, while the off-balance sheet includes assets and liabilities such as loans that are not recorded on a company's balance sheet. In SSL's case, the assets and liabilities on its off-balance sheet are reportedly not owned by the company. Tomlinson has reportedly verified over 98% of the assets on the off-balance sheet. It is not clear whether the amounts that allegedly disappeared from at least 40 clients, including sprint legend Usain Bolt, are included. The alleged fraud stretches back at least 13 years. Some of the findings are being used by the FSC to seek permission from the Supreme Court to submit a request to wind up or liquidate SSL. An application was filed in early March. Now, liquidation refers to the process through which the affairs of a limited company are wound up or brought to an end, and the assets and property of the company distributed to its creditors, and if any remains, to its members. This turn of events also backs up a previous report that SSL has not been paying its taxes. Up to January 30, SSL owed the state 40 million, some representing deductions from employees' wages. It also has emerged that 62% of SSL assets are monies due from related party companies. That amount is approximately 710 million. The funds are uncollectible at this time, noted one source. According to the source, the remaining 32% of the assets that total 432 million, which if disposed of at a fairly conducted sale under legal process, would not be sufficient to enable payment of SSL's obligations that are due and occurring. The matter concerning connected party transactions is a major focus in the multi-agency law enforcement probe involving the Financial Investigations Division, the Police Fraud Squad, and the United States Federal Bureau of Investigation. British firm Kroll Associates has been engaged as forensic auditors. The application by the FSC for permission to seek a wind-up of SSL is to comply with Part C of the third schedule of the FSC Act. It says within 60 days of taking temporary management of an entity, the FSC shall apply to the court for an order confirming the vesting in the Commission of full and exclusive powers of management of an entity, determining whether to continue or discontinue a company's operation is among the powers of the FSC. Within the same period, the law also requires the FSC to determine whether to restore the company to its board of directors or owners, present a winding up petition to the court, or propose a compromise or arrangement between the company and its creditors.